Today's My Carolina Legal Advice. Joining us is Stephanie Jenkins from Gaylor, Wallace & Hunt. And today we're talking about probably one of the most difficult aspects in family law, and it has to do with challenging custody cases for children.
Yes, Sharon, it is one of the most challenging things I deal with as a lawyer, because you're dealing with cases where for most of the time my clients are going to tell me that the most important thing to them in any case is their children. And all that I can tell them initially when they come in is that the polar star, the guiding light for a judge, if a judge is asked to decide, is what is in the best interest of their children. That's the legal standard. And a judge has a lot of discretion. And so you're going to have to pay attention to the really minute details of a case, or sometimes the glaring issues in a case, to try to guide somebody about what they ought to do.
Now, I think there were, for many years, a lot of assumptions that mom always got custody of the kids. But nowadays, things are so different with dual working families, and sometimes mom is breadwinner nowadays as opposed to dad, and then alimony plays into that, and the amount of time a parent is at work. What are some issues that people can look at in preparing for something like this?
Well, first I will tell you that there is no longer a maternal presumption or a tender years presumption. In North Carolina,
tender years is the young little ones.
Yeah, there was a period of time in North Carolina and other states where there was a presumption that children of tender years ought to be with the mother.
And that is no longer the case.
That is no longer the law in North Carolina. It's going to be a case-specific determination, because there could be a situation just like you talked about, where the mother was the one who went out to work. No offense to working mothers, I am one myself.
Right.
But the mother went out to work, and the father was very integrally involved in the child's development and upbringing from a very early age. And so there would be no presumption that just because the child was young, that the custodial situation would automatically go with the mother.
There are a growing number of stay-at-home dads, as we know. Allegations of abuse, neglect, or violence, that obviously is now bringing in the criminal element.
It can bring in the criminal element. Abuse, neglect, violence allegations are some of the more difficult ones that I deal with when I'm trying to counsel clients. Either clients who fear that those activities are going on and being perpetrated against their children, or people who have had allegations made about them that they've done those things. You have to be
And sometimes it's not true, but trying to prove that that's not.
Absolutely. So it's really a double-edged sword sometimes. You're trying to talk to clients who fear this is happening to their children and letting them know that they need to be very careful about proving it before they make those allegations.
Sure.
Because the system is so frequently abused. And then you may be talking to someone who has had those allegations made against them falsely and is dealing with it both in a civil context and in a criminal context.
And that leads to the potential or awareness for abuse of what is happening. The CPS, which is Criminal or Child Protective Services, which is under the Department of Health and Human Services, could get involved. Mental health of parent or child, is that looked at as well?
Absolutely. Absolutely. And it should be looked at both as a family lawyer dealing with it and hopefully a judge who's really attuned to the situation. The mental health of the parents can often be a deciding factor in a case. If you have one parent who has a mental disability who is not dealing with it, it's definitely going to affect the custody and well-being of the children.
And quickly, as we go through the other points, child support that would be independent from custody or visitation.
Yes, sometimes the supporting parent will say, well, I'm not getting to see the child, I'm not going to pay child support. Or the custodial parent will say, well, he's not paying child support, I'm not going to let him see the child. And when I say he, that's not necessarily the vernacular, but in North Carolina, they are not coexistent. They are mutually independent legal issues. So you are not allowed to withhold visitation or custody just because you're not getting child support, and you are not allowed to withhold child support because you're not seeing the children.
Right. Okay. All of this information is available on your website, Stephanie, at Gaylor, Wallace & Hunt's website. Plus, it's also available on our website as a resource at mycarolinatoday.com. Stephanie, thank you so much.
Oh, thank you.